What do you think of the support for Lindsay Clancy out here?
I have no words.
No words.
It's amazing.
As the Lindsay Clancy murder trial draws to a close, her defense continues fighting to prove the 36-year-old former nurse was suffering from undiagnosed postpartum psychosis when she strangled her 3 young children in January 2023. Spearheading that team is 75-year-old white-haired attorney Kevin Reddington, a veteran trial lawyer with over 4 decades of experience and a reputation for aggressively taking on complex mental health cases. Battle-hardened from decades of courtroom clashes and armed with relentless style, he has delivered some of the trial's most fiery, decisive moments. Here are his top takeaways from the trial so far. From the get-go, he showed no hesitation in going after medical professionals on the witness stand. When cross-examining Dr. Jennifer Tufts, the physician who treated Lindsay and prescribed various psychiatric medications, Reddington aggressively challenged how Lindsay's deteriorating condition was documented, grilling the doctor over contradictory entries regarding Lindsay's speech and anxiety.
Can you just read this paragraph here for us?
No sleep last night. Falls asleep after 40 minutes. Heart racing, severe anxiety. Worrying about kids, baby, sleep. Yawns but not drowsy. Not hyper, pressured speech.
What was that? Not hyper what?
Not hyper, not pressured speech is what I meant. I know it doesn't say not, but that is exactly what I meant.
Wait, when did you see this that you noticed that it did not say not?
I don't care what it says. I know what I meant.
Well, when you wrote this, you did not say not pressured speech. You said in the medical record, pressured speech, right?
No.
Does it say that?
Yeah, the word not is right before not hyper, comma, pressured speech.
Right,
The two
so
are following the
comma mean
not.
to you? When you put down in a medical record, heart racing, comma, severe anxiety, comma, worried about kids, comma, baby, comma, sleep, comma, yawns but not drowsy, period. Not hyper, comma, pressured speech. That's what you wrote, right?
She did not have
Did you
pressured
write
speech.
that, doctor?
I wrote that, but you're misinterpreting my note.
Am I reading this correctly, and the jury will be able to look at it, that you put not hyper, comma, pressured speech? Did I read that right?
Yes, but your interpretation is incorrect.
As opposed to yours?
Reactions at the defense table often spoke louder than words. On day 15, as prosecutor Shannon Buckingham voiced an objection to the judge regarding defense exhibits, arguing they were inaccurate and disclosed late, Reddington stood by, smirking, visibly dismissing the state's claims before launching into his own response.
And putting aside the late disclosure and the fact that I don't know if anyone who created this is going to come in and testify that they created it and whether it's to scale or not, but the main objection is that it's inaccurate.
All right, Mr. Reddington. Thank you.
Tensions routinely flared over evidentiary disputes as the state attempted to block key exhibits. On day 15, when prosecutor Shannon Buckingham stood up to object to items being presented to the judge, Reddington immediately interjected with a blunt no, shutting down the objection on the spot.
So I guess, Commonwealth, have you had an opportunity to take a look at these?
Yes, and we are objecting to these items. Yeah.
All right. And so why don't we discuss those here in open court and go through it.
Taking physical command of the courtroom became a hallmark of the defense's strategy during crucial testimony. While Lindsay's mother, Paula Musgrove, was on the stand recalling how her daughter begged for her to stay with her during severe bouts of insomnia, Reddington stepped away from the podium to present a massive poster board displaying the printed text messages directly to the witness stand for the jury to see.
Do you have a copy maybe that she could look at?
Oh, I have a copy.
Yeah, that might be easier for the witness.
So I'm going to approach you with this board and ask if this is a copy of the text that you're referring to.
Clashing directly with the prosecution was standard procedure when trying to establish how healthcare systems outside the U.S. treat postpartum depression and psychosis. As prosecutor Buckingham tried to object to his line of questioning, the defense attorney turned toward her, snapped, "Let me finish," and pushed forward to demand a clear yes or no from the witness.
You familiar, sir, with the way other countries treat pregnant women in postpartum condition when they see let me finish. When they see a doctor for medical treatment? Yes or no?
Objection.
All right, just
Sharp wit and quiet confidence were frequently deployed to counter state filings. As the prosecution addressed the judge regarding a revised medical affidavit, pointing out that key opinion sections detailing Lindsay's suicidal ideation had been omitted, Reddington calmly rested his hand on the back of his chair as they read out their argument.
So we were provided another affidavit, which appears to factually have the same numbered paragraphs and just deletes the ultimate opinion section and adds that Dr. Tufts and Nurse Gelato were aware that Lindsay was experiencing symptoms of suicidal ideation and a critically deteriorating condition while under their care and failed to take reasonable steps.
Eagerness to take back control of a witness led to one of the quickest transitions of the trial. The veteran lawyer jumped up to the podium before prosecutor Shannon Buckingham could even sit down. As the judge paused to let the prosecutor take her seat, Reddington waited for her to pass, then immediately pivoted to address the jury on confirmation bias.
I have no further questions at this time.
let's talk about confirmation.
Can I sit down, please?
Hold on. Let Ms. Buckingham
Thank you.
have a seat.
Confirmation bias.
Dismantling digital evidence presented by the state resulted in one of the trial's most heated exchanges. Here, Reddington throws his hands up in frustration and disbelief while cross-examining Massachusetts State Police Sergeant Kyle Pavow, a digital forensics investigator in the cybercrime unit.
You're not able to tell who's actually at the computer doing all of this, correct?
No,
You can only see what data there is and what's been accessed, correct?
correct.
Thank you.
All right, Mr. Reddington.
That's it? That's your testimony? That's why you're here today, to talk about a search that was involving Tim Hall?
Sustained, if you could,
So I apologize. Your testimony today is based on that search on August 23rd, right?
Correct.
Of 22, right?
Kevin Reddington's 4 decades of trial experience have defined every step of this defense. And with the trial winding down, Reddington's high-stakes gamble to prove Lindsay Clancy was not criminally responsible is entering its critical final phase.